right, thank you all for being here. Thank you to our panelists once again. My name is Cody Graves. I'll be your moderator for tonight. And I'm going to real quick show you how this is going to work. So this is going to be our order of speakers. Dr. Henry, being our neutral party who will be talking about constitutional law, is going to be going first and last. So for his first, he will have 15 minutes to talk about constitutional law and how that relates to abortion. And he'll end it with a 5-minute response to tease out whatever constitutional issues came up during the talks of our other panelists. So to decide who was Speaker 1 and Speaker 2, we did a coin flip, which Mr. Dombrowski won, so he will be Speaker 1. So then how it's going to go, Speaker 1 will get 15 minutes to start and tell his side. And then Speaker 2 will get 15 minutes to tell her side, and then they'll each have 5-minute responses to respond to what the other said. So without further ado, Professor Henry, you have 15 minutes.
All right, well, thanks for showing up. Thanks for the panelists. I appreciate your driving the distance as you did. Especially thanks to you all for coming out. I know it's a gorgeous day out, and for those of us who haven't seen the sun in 3 months, it's quite a sacrifice. So I'm glad you all could make it. What I'm going to do is talk about the legal developments. This is going to be a very big picture survey of what's been going on in terms of abortion case law. So for those of you who are more constitutionally acute or knowledgeable, you may want to have questions about that. That'll be fine. Just give you more of a big picture related to I think the topics that will be coming up later in the evening. So let's talk about the case history coming from abortion. Early throughout most of American history, abortion was a crime under the common law, and there's been some dispute about the history regarding this, but for the most part, it's now understood that, that it was a crime not just for purposes of protecting women's health, but also for purposes of fetal life. It's important to note that what you have during this time period is a state-by-state approach to abortion. There is no national abortion policy. The abortion policy is varied by the state. And that's the way it was until 1973, when we have Roe v. Wade. Roe v. Wade is the case that nationalizes abortion policy. Prior to 1973, nobody asked a presidential candidate what he or she thought, well, back then only he, what he thought of abortion, right? Because it wasn't a national issue. It was purely a state issue. Roe v. Wade nationalized it. Now, it's a little tricky to talk about abortion constitutional law principles because they tend to vary based on the case. There's a great deal of variability that you see as you go from case to case. And this is a tricky thing, right? I mean, it's difficult. So what I'm going to do is sort of highlight some of the relevant parts of the cases, and then you'll get a sense, I think, of what's going on. Roe v. Wade establishes a right to an abortion based on right to privacy, loosely derived from the 14th Amendment. If you don't know what that means, don't worry, we're going to move right along. And go straight to the rubric that Roe v. Wade laid out. Roe v. Wade sort of roughly uses a trimester basis, and Roe sort of tries to balance what in their mind were competing interests. The competing interest of, on the one hand, the state's interest in fetal life, and on the other hand, the woman's interest in her own body and her own rights. And so Roe sort of has this sliding scale where as the fetus approaches viability, then the state's interest in fetal life also increases. And that's extremely important to understand about Roe. And so you have a trimester based on viability, and that's sort of a very big deal. This is one of the classic lines from Roe v. Wade, from the majority opinion in Roe v. Wade, and in many ways I think sets up the discussion that we're going to be having today. The majority opinion said, we need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary at this point in the development of man's knowledge is not in a position to speculate as to the answer. And then some would say that they proceeded to go and do that precisely in Roe v. Wade by nationalizing the issue based on a judicial opinion. Okay. The sister case to Roe v. Wade is what most people aren't as aware of, and that's Doe v. Bolton. And it's important to always connect Roe and Doe. Doe v. Bolton famously includes a health exception, which Roe also does. But in Doe, the court clarified that a woman has a right to an abortion whenever it would affect her health. And Doe specifically defines health to include mental health. And that's very important for understanding America's abortion policy. That's why, although technically Roe allowed for a trimester schedule, they gave a really big loophole based on the health exception and then defining health as including mental health. And the two classic quotes from Doe on this would be, quote, "The medical judgment may be exercised in the light of all factors, physical, emotional, psychological, familial, and the woman's age relevant to the well-being of the patient. All these factors may relate to health," and then more famously in Roe's connection to this, "Psychological harm is included, mental and physical health may be taxed by childcare, distress associated with the unwanted child, stigma of unwed motherhood." So these are sort of emotional and mental concerns that are included within the rubric of the health exception clause that you saw in Roe and Doe. All right, moving right along. Akron, the Akron Center for Reproductive Rights. The Akron case basically just now declares there's a fundamental right to an abortion. That's an important thing in terms of constitutional law. The transition to a fundamental right means that it's a much more solid right, and it's much more difficult for states to argue their regulations on abortion. And now the very famous Planned Parenthood v. Casey. If you're going to know 3 cases about abortion, this is going to be one of the 3 that you have to know. The Casey decision was a shock and a surprise to many people throughout America, because at this point, the Republicans had put a number of justices on the Supreme Court, and it was widely assumed that the Casey majority would end up striking down Roe v. Wade, and that is not what happened. Instead, the Casey decision gets rid of most of the elements of Roe v. Wade. They do get rid of a lot of them, but they replace them with other things. And so by this point, it's become clear that the trimester viability sort of approach to abortion has become tricky, because increasingly scientific advances were pushing the age of viability further and further closer to conception, right? Which sort of makes it tricky. How can you have a constitutional right that's constantly changing based on scientific advances? And so that's one of the reasons why the Casey court replaces the trimester framework with an undue burden test. So the question then was, does this regulation place an undue burden on a woman who is seeking an abortion? They also replaced the right to privacy with due process. That's sort of the constitutional justification that they're relying on. They're just, and I'm not going to stress this, but with each case you have a different constitutional clause that is being relied on to explain why there's a constitutional right. In many ways, from a constitutional perspective, it sort of looks oftentimes as though you have a conclusion in search of a constitutional argument, and each case you get a different argument. So it's sort of, it's one of the tricky things with abortion case law. They rely on precedent, but this is one of those, and a concurring opinion, and the concurring opinion is the reason why Casey doesn't strike down Roe v. Wade. And this is a really fascinating argument. Sandra Day O'Connor joins with 2 other justices, and basically she says, you know what, Roe v. Wade was wrongly decided. We totally screwed up there. That was a huge mistake. But she then says this, that overturning Roe would result in, quote, both profound and unnecessary damage to the court's legitimacy and to the nation's commitment to the rule of law. So, with the Casey decision, you basically have the court saying, boy, we screwed up on the Roe case, but by this point, we really can't change without having damage to the rule of law, without damaging our institutional legitimacy. So that's why this is sort of a very famous moment. We're very unusual to have a court, they do this all the time, but they rarely say that they do this. Rehnquist then responds in the dissenting opinion to say, our constitutional watch does not cease merely because we have spoken before on an issue. When it becomes clear that a prior constitutional interpretation is unsound, we are obliged to re-examine the question. And that's basically been the 2 perspectives on abortion policy that we've seen ongoing. On the one hand, you have those who argue that, you know what, Roe v. Wade has been around for a while now, therefore women are relying on their constitutional right to an abortion. We really can't change without undermining the Supreme Court's legitimacy. On the other hand, you have the conservatives on the court who say, well, it was wrongly decided from the beginning, so we need to re-examine it regardless. All right. From there we go to a case that causes everyone to sort of question, and this is really, so I've told you there are 3 cases you have to know. Roe, you presumably know. Casey, you have to know. Carhart v. Gonzalez, or Gonzalez v. Carhart is really the big one now. This is what's caused everyone to take another look at the Supreme Court. This is the so-called partial birth abortion case, the one that was upheld, the congressional case that was upheld. And in this case, the majority opinion relies on a rational basis test for upholding the law. Now, I know this is sort of getting boring and constitutional and political and legal and so forth, but that's a really big deal in constitutional jurisprudence. To explicitly say that the state only needs a rational basis in order to regulate abortion means that states have a great deal, might have a great deal more room to regulate abortion than they have in the past. Does that make some sense? So that's why the Carhart decision is an extremely big deal. And it's an extremely big deal because it also explicitly lacks an exception for the mother's health. And this is a very big deal in abortion policy. So this is basically, it looked as though Kennedy, who as always is the swing vote, was perhaps allowing more room for states and Congress to regulate abortion. And that explains, partially, why about over the last 4 years you've had a slew of states that have passed abortion laws, right? You might know this. A number of states have passed laws that have tried to outlaw abortion at various stages, right? Whether based on fetal health, or heartbeat, based on fetal pain, and so forth. So I'm going to give you one of the examples from recent history. It got some press, so you might be aware of it. Also, just these are the questions that we need to ask. Who decides? When can states protect fetal life? And the example I wanted to give you was the Texas House Bill 2. This is if you remember this, Wendy Davis was wearing pink sneakers and arguing, doing a filibuster on this, got a lot of press. I believe she's now running for the governor, to be governor. This bill does a number of things, but the things that are going to be constitutionally interesting, I think, are going to be mainly this one. It requires abortion doctors to have admitting privileges at nearby hospitals. And what's going on here is Texas is basically trying, it also requires additional restrictions, for example, if you use RU486 and some of the other pills, the abortifacient pills and so forth. Why is this interesting? It's interesting because what Texas is doing, it also outlaws all abortions, I think, after 20 weeks. But what's interesting about this bill is going to be this. The question is, can a state use very strict regulations which might result in shutting down abortion clinics, right? And this bill has temporarily shuttered over a dozen clinics in Texas. There are some who have to drive, I think it's now like 600 miles to get to an abortion clinic in Texas. So that's sort of a big question, right? The question is this going to be constitutional, or is this does this not pass the rational basis test? So that's going to be the case that a lot of people are going to be paying attention to. All right. All that is to go to what are the positions that you can hold to constitutionally on abortion. And the standard pro-choice argument that constitutional terms that you tend to have is based on precedent now. That's one that you oftentimes hear. The standard pro-life argument was to simply say you need to overturn Roe v. Wade. And those are the ones I imagine you've always heard. What you're going to see, I think, over the next 5 to 10 years is you're going to see 2 different arguments being developed on both sides. And I just personally think they're more interesting arguments. And of course, as you know, if I think they're interesting, you're going to hear them. The first argument is going to be based on substantive equal protection. And this is going to be the argument that I think you're going to see the pro-choice crowd gradually, increasingly adopt. Ruth Bader Ginsburg is a justice on the Supreme Court, and she has already hinted at this in several speeches. And the argument is to say this. Well, this is from Planned Parenthood v. Casey. In some critical respects, the abortion decision is of the same character as the decision to use contraception. The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. This quote, I believe, is why the 4 conservative members on the Supreme Court did not want to question abortion policy. They could have taken, I think the Arizona case was the last case, or the Arizona bill. They could have allowed abortion to be ruled, or to be illegal after 20 weeks, and they didn't want to hear that case. Why? It's because of this quote. And I think the reason is because they're concerned that Justice Kennedy will go substantive equal protection on when it regards to abortion rights. What does that mean? The argument basically says that in order for women to have equal rights in society, it requires that they be freed from the possibility of pregnancy, which could harm them socially, politically, and economically. Does that make sense? So I think that's going to be the argument that you're going to see gradually develop. It's a new argument constitutionally. The other side, you're going to see the pro-life argument is going to be based on Roe v. Wade, and this argument basically simply says that they can use the 14th Amendment to ensure the rights of fetuses, and so this means not just removing Roe v. Wade, it means more than that now. Now I think you're going to see the pro-lifers arguing specifically for the rights of the unborn as opposed to simply removing Roe v. Wade. So there we go. I knocked you at 15 minutes. I think I gave you a lecture and a half. Hopefully some of it sank in. All right.
Thank you so much, Dr. Henry. Okay, so now we will be giving Dr. Dombrowski 15 minutes to state his side. Your 15 minutes begin when you speak.
You can hear me in the back? Okay. I wonder if I could give a historical argument for the pro-choice position. I know a lot of people assume that in the history of Christianity you just have to be opposed to abortion, but actually I think the issue is very complex in the history of Christianity about how to view the fetus, especially the moral status of the early fetus. I wonder if I could start by making a distinction between two different senses of being human. You can be human in some sort of biological or genetic sense on the one hand, and then you could be human in a moral sense or a personhood sense on the other. And I think all of us can agree that the fertilized egg, fetus throughout its development is human in the genetic sense. So that's not what's in question. The debate largely concerns whether or not the fetus is human in a morally relevant sense, whether or not it's human in a personhood sense. And what I'd like to suggest is that in the history of Christianity, this has been a hotly debated question, and there are two quite different positions that have been in the history of Christianity regarding the moral status of the fetus, especially the early fetus. One view is called the delayed harmonization view. You may have picked up a handout on the way in where these words are on the handout. The delayed harmonization view is the dominant view in the history of Western Christianity. It was pretty much the standard view until about the 17th century. The delayed harmonization view is one that suggests that the fetus in the early stages of pregnancy is not a person, and it has to go through certain developmental stages such that eventually it goes from a vegetative state to a sentient state when it can start experiencing pleasure and pain on its own, quite apart from the mother's pleasure and pain. And then only when it's in a sentient state does it have the necessary conditions such that it could then be a repository for something that would make rationality possible. This is the view held by Saints Augustine and Thomas Aquinas. Thomas Aquinas is heavily influential in the Catholic tradition. St. Augustine is enormously influential in the Protestant tradition, as you realize. Both of them were delayed harmonization theorists. Neither one of them thought that aborting a fetus early in pregnancy was murder or anything even closely approximating murder. This is, I think, one of the best kept secrets in the history of Christianity, that its dominant thinkers up until the 17th century were delayed harmonization theorists. Now, there's another view called immediate harmonization, and you're familiar with this view. This is the view that suggests that the fetus is human not only in a genetic sense, but also in a morally relevant sense from the moment of conception on, okay, that it's human in a personhood sense from very, very early on in pregnancy. It gets a foothold in Western Christianity only or becomes sort of a major player in Western Christianity only in the 17th century. So it's a very interesting question to ask as to why there's this shift from the delayed harmonization view to the immediate harmonization view. It looks like the best way we can explain this transition is in terms of certain developments in magnifying glass and microscope technology in the 17th century. So when Leeuwenhoek invents the microscope and when scientists start developing magnifying glass technology, embryologists looked at fetal developments in non-human species. So they looked at chickens, and then they, this is in scare quotes, saw a fully developed chicken from like one day into chick gestation. So it was a fully developed chicken with wings and feathers and a beak and everything. And so the idea was it just gradually got bigger and bigger and bigger, but there was a fully developed chicken from the very start. The inference was that if we looked at early fetal development in human beings, what we would find is a fully developed human being from like the first day or two of pregnancy, with toes, and eyebrows, and so on, fully developed. And then fetal development consisted in this fully developed being just getting bigger and bigger and bigger. Okay? The technical word for this being is called homunculus, a fully developed human being, only microscopically small. It turns out that that is completely wrong scientifically. Okay? There is no homunculus. Right? Initially, there's a single-cell organism that you need a microscope to see, and then you need cell differentiation and growth over 9 months of pregnancy. Right? The belief in a homunculus is what fueled the immediate hominization view. And unfortunately, from my point of view, we're probably going to disagree on this point, right? But unfortunately, from my point of view, when the scientific mistake was corrected, the moral implications of the homunculus view were not forgotten. And people still, in some circles, tend to think that there's a morally developed, right, or a person present in the early stages of pregnancy. Basically, what I'm trying to do here in this historical argument is just to create a little bit of elbow room for friendly conversation in Christianity about the abortion debate. In other words, I can see why some people might want to defend the immediate hominization view, but I'm trying to suggest that there are also good reasons, both historical reasons and then also other reasons for taking the delayed hominization view seriously. It seems clear to me that a pregnant woman is a person, right? Is a person in the morally relevant sense of the term. It's highly questionable to me whether or not a fetus early in pregnancy, before the development of the central nervous system, is a morally relevant being, is a person. It strikes me as wildly implausible to think that a single-celled organism early in pregnancy should receive as much moral respect as any one of you in the room. I think that trivializes the rights of the woman who's pregnant to think that the very early fetus is on a moral par with her. I think you have to know a lot about science in order to discourse intelligently about the abortion debate, but I don't think that it's a debate that can be resolved by science. Immediate hominization theorists tend to emphasize the evidence from genetics that you may have heard of, that a fetus early in pregnancy has all the genetic material we'll ever get, so it's somehow or another destined to become a human being later on. However, delayed hominization theorists like myself can point to a lot of evidence in embryology. Right? It's not, nerve cells may develop relatively early, but a central nervous system which would allow the fetus to be a sentient being in its own right doesn't come on the scene until the late second trimester or early third trimester. So actually, I think there's a lot of wisdom in the Roe v. Wade decision in permitting abortion early in pregnancy, and also in allowing states to make certain sort of regulations, perhaps prohibiting most abortions late in pregnancy. Many people in the pro-choice movement will be willing to say what I just said. Okay, in other words, I can understand why people would have moral qualms about a lot of late abortions. But it seems to me it does make sense to give women a carte blanche to abortion relatively early in pregnancy before the development of sentiency. So although the criterion I would defend is different from the Roe v. Wade criterion, so the Roe v. Wade is going to see viability as crucial, as indicated. I'm going to make sentiency sort of the threshold point at which a being becomes morally considerable. However, from a practical point of view, there's not much of a difference there because viability and sentiency occur about the same time. Okay? So intellectually, the criteria are different, but they occur about at the same time. So I think in terms of the time span within which Roe v. Wade would permit abortions, without question, I think is basically just about right. I know there are going to be some people who are going to be angry when I say this, so let me apologize in advance. I'm not aware of a single passage in the Bible that explicitly deals with the issue of abortion. And once again, I'm trying to just create some elbow room for friendly conversation on this issue in the history of Christianity. I've heard dozens and dozens of passages, right, that people will cite in the pro-life camp, but it's not the sort of issue that is explicitly treated in the Bible. This should allow one some room to think carefully, philosophically, and not just theologically, about what to make of the moral status of the fetus. I think there are good utilitarian grounds for developing the view that I'm developing in terms of delayed hominization. In other words, I'd like to protect as many beings as possible who have well-being, but until you're a sentient entity, it's not clear to me what it would mean to have a life that could go well or ill for you. In other words, until a being is capable of pleasures and pains on its own, it's hard for me to see how it could be seen as a locus of moral respect. So if you ask the question, why be opposed to abortion, the dominant answer in our culture is in terms of the immediate hominization view, right? I mean, the people who are opposed to abortion tend to think that the fetus, even in the early stages of pregnancy, is a baby, right? Is a person worthy of moral respect. That's the view I'm trying to unsettle, right? That's the view I'm trying to destabilize and suggest, that historically and in many other ways it is a questionable view. However, there are some people who want to be opposed to abortion by claiming not so much that the fetus in the early stages of pregnancy is a person, but rather they want to claim what? It is potentially a person, right? Or it is destined to become a person. And I'd like to say a few things about that, and then I'm willing to call it quits. Let Camille take over. I'm not opposed to teleology with a lowercase t, okay? In other words, it seems to me that the fetus, even in the early stages of pregnancy, has something built into it, such that the fetus in the early stages of pregnancy cannot grow up into an adult horse. Okay? It is sort of driven in a certain sort of way that is human rather than equine, right? It's not going to become a horse. However, I'm really skittish about people who develop a teleology of the fetus with an uppercase T. There are some people who want to say what? That if it were not for abortion, the fetus was destined to become a human being. Right? Or if not for abortion, the fetus would have become an infant. Now it strikes me that that's a little bit too strong, that sort of language. I've read quite a bit of embryology textbooks, and apparently less than 1/3 of fertilized eggs are ever eventually born as infants, quite apart from humanly induced abortions. That is to say, nature performs abortions at a much higher rate than any human society. So less than 1/3 of fertilized eggs eventually are born as infants, quite apart from humanly induced abortion. So what I'm trying to claim here is that it's not the case that if a fetus were not aborted through some sort of humanly induced abortion, that it would definitely have become an infant, or it definitely would have been born. It's actually unlikely that it would have been born. So that teleology with a lowercase t does not bother me. I'm skittish about teleology with an uppercase t, whereby people might want to claim not so much that the fetus is a person, but that it has such a strong potentiality to become a person, right? That we are, in effect, killing a human person if we abort early in pregnancy. And I'm trying to call that view into question as well. So I'd like to rest the case on the claim that the pregnant woman clearly is a person. I don't see clear arguments in favor of the claim that a fetus early in pregnancy is a person, and that has all sorts of practical ramifications in moral theory as I see things. Thank you very much for your patience.
Thank you, Dr. All right, Mrs. Pauley, you have 15 minutes beginning when you speak.
Thank you. I'm going to stand just because I'm a small person, if you don't mind. Dr. Dombrowski and I are both Catholic, and I come to the abortion issue from both a very personal perspective as well as a very public perspective. On a personal level, I believe that abortion is very beneath the dignity of human persons, including women, and here's why. I think it's very important that when we talk about abortion, we be very willing to talk about the issues of happiness, and the issues of love, and the issues of quality of life, and the issues of freedom. Because those are very personal issues that found and ground the very meaning of life itself. Every human person wants to be free, wants to be happy, wants to have a high quality of life, and wants to know love. But we do a very poor job in this culture, I think, of explaining what those things mean. I have a 1-year-old daughter and a 4-year-old daughter, and I didn't give birth until I was in my 40s. I didn't get married until I was 38. And so I had children very late in life. And one of the things that bothered me the most when I was pregnant was the number of people who thought it was irresponsible of me not to engage in genetic testing so that I could find out whether or not my children would have a genetic disability so that I could abort them. To me, there's something very wrong with a culture that believes it is irresponsible to not abort children who would have a genetic disability. And that's where we are today. But it comes because I think people have profoundly narrow views of what it means to have quality of life and what it means to be happy. When my 4-year-old daughter was 2 years old, we used to teach her big words like onomatopoeia and ontological and transcendental. And one day while I was changing her diaper, she said, "Mommy, what does transcendental mean anyway?" And I said, "Well, it's something that's really real, but you can't touch it." And she said, "Oh, you mean like the toilet?" And I think that that gave us a good insight to what's wrong with our culture when it comes to issues like abortion. We have a very narrow and incomplete sense of what transcendentality means. We don't think about the transcendentals when we're discussing happiness and love and things like freedom and quality of life. But happiness is a significant term in abortion. There are 4 different ways, historically, that people have defined happiness, and 4 different ways you can achieve happiness. One is through pleasure and possessions, through being a sentient being. But there are far deeper ways to define happiness most people would consider. There's the happiness that comes from ego gratification, or being better than others, or being successful or powerful. There's a third kind of happiness, happiness that comes from making a difference beyond yourself to the good of someone else, engaging in acts of generosity or compassion or self-sacrifice for the good of another human being. And then there's the 4th level of happiness, which would be happiness through faith. What someone with faith would describe as a kind of happiness that comes from a deep and abiding peace in knowing that you are unconditionally loved into eternity by an unconditionally loving eternal source. So that would be the faith perspective. Here's my point. I think our culture radically overemphasizes levels 1 and 2, the physical pleasure, the possessions, and the ego gratification, above and beyond levels 3 and 4. To me, I think we do a grave disservice to women when we say that it's beneath women's dignity somehow to sacrifice ourselves for the good of another human person, particularly our own children. I think the greatest happiness that human beings experience comes from when we let go of ourselves and our own desires for physical pleasure and ego gratification, and instead seek what is truly worthy of us, which is true love, gift of self, and generosity, and compassion, and self-sacrifice, and care, and compassion. And I think that one of the greatest ways that a woman can accomplish this is through giving up her own life, metaphorically speaking, or even really speaking, for the life of her own children. Now, as I said, that's a very personal reason for being pro-life. And in a pluralistic society, you can't force everybody to become level 3, level 4 people. People can choose whatever form of happiness or whatever definition of love they want. But there's also a very public reason why I am pro-life. And it is a reason based on rational principles. And these are principles that I believe if we abandon, we lose civilization itself. And that's why I think we can't just leave this as a friendly conversation. We must also be very serious in whether or not we want to keep or abandon these principles, because our civilization depends on it. And these are the principles that I want to share with you. Logical principles, ethical principles, and principles of justice. Let me explain. The first argument, of course, is whether or not this being is a full human person. And Dr. Dombrowski is right. Genetically, we can all agree it is a living, growing human being. But is it also a human person, something we give moral worth to? I believe that the moment you disassociate human being from human personhood, you have already entered into a subjective domain that is extremely dangerous. because now your only criteria for claiming that there can be human beings who are not human persons is completely subjective. Whether or not it feels pain, what does that have to do with whether or not you are a full human person? Whether or not it has a certain IQ, whether or not it has developed to a certain degree? There's an important principle in philosophy that I'll call the principle of complete explanation. When you really want to know what something is, you can't just look at it physically or genetically. You also have to include all of the data about that thing that is present to us. And we know that part of being human are these transcendental experiences. The human search for love and goodness and compassion, the search for truth, the search for justice, the search for eternal home or peace. We desire these things, and so that search is a part of what it means to be a human person. Therefore, human beings are not just genetic beings. We're not just biological beings. We also automatically have a moral aspect to our nature. Our nature is such that it has the potential to seek the transcendentals. But here's where the mistake is made. If we begin to argue that you are only a full human person when you are engaging in that search for the transcendentals, when you are actually consciously seeking love, or seeking compassion, or seeking goodness, you are making the grave mistake of counting out everyone who is a human, who could be a human person, but is not actualizing that right now, including when you are sleeping, when I am engaged in unloving acts, when we are engaged in unthinking acts, when we are in any moment of our lives that we're not pursuing those transcendentals. The better argument, I think, is that what makes you what you are your powers, your potentialities. And so a human person has to be defined as a being which is capable of pursuing the transcendentals. And an unborn child, from the moment of fertilization, it contains a nature, has the essential nature that is necessary to pursue the transcendentals. All it needs is growth, nutrition, physical development, and that's all. It's the same thing that you and I need. If we begin to say that you have to actualize those powers in order to be a human person, then you need to be consistent. What about a 6-month-old baby outside of the womb who doesn't pursue any of the transcendentals? Or my 2-year-old daughter who doesn't even know what a transcendental is? What about a 4-year-old or a 6-year-old? What about anybody who hasn't studied those issues? When we begin to say you have to actualize your powers to be what you are, that's when we get into danger. There's another principle that's called the principle of full human potential. This principle was developed by a man named Bartolomeo de las Casas, who was a Spanish Dominican in the 1500s, and he was fighting against the Spanish conquistadors who were torturing, enslaving, and murdering the Native Americans, or the American Indians, on the grounds that they weren't as fully developed as the Spaniards were. In the eyes of the Spaniards, the Native Americans had more primitive forms of art and architecture and language and religion and studies of the sciences, and therefore they were less developed and so less than full human persons, and so had less worth. The same argument my opponent is making. The problem with this argument is twofold. Number one, if you had allowed the American Indians the education and the opportunities to learn about the things the Spanish had access to, they would have developed probably at the same rate and possibly exceeding the abilities of the Spaniards. But more than that, the Spaniards were overlooking a very important aspect of the human person. That the Native Americans weren't torturing, at least the ones the Spanish were after, weren't torturing, enslaving, and murdering other people like the Spaniards were. So in one sense, they were far more developed than the Spaniards were. Here's the point of the argument, though. The point of the argument is that what makes you a human person with value and worth is not the level of development you have currently achieved. Bartolomeo de las Casas' argument is, what makes you a full human person with full human worth is the level of development you could achieve if allowed to reach your highest level of actualization. If we abandon this principle, then most of the students in this room would not have full human personhood and would not have full human worth, because you don't even reach your highest level of development biologically until you are at least 20 or 21 years old. For some people, it's 22. Furthermore, many people, all of us after that point, begin to lose our biological development a few years after that. when your body begins to break down and your mental abilities begin to break down and your memory begins to break down. And so I think Bartolomeo de las Casas' argument is extremely important, that we don't value human persons based on what we are capable of achieving now in the present, but based on what we could achieve if allowed to reach our highest level of actualization. And for a single-celled zygote, and even in the woman's fallopian tube, that child has the same capacity to actualize the same level of development as you and I. It is merely in a stage of earlier development. And this leads to the final argument: human rights. Human beings have human rights because of our human nature. We have natural rights that exist because we are of immeasurable value, because we have a transcendental nature. Those natural rights are life, liberty, and property. And they're natural because those rights are necessary for our nature to exist. We can't pursue love or compassion or truth or justice if we don't have life, present existence, or liberty, the freedom to pursue those things, or property, which is a sense of security about you so that you're not constantly in fear of becoming somebody's indentured servant. Now here's the key to these rights. They're natural, they're a part of your nature, which means natural rights exist when human personhood exists. And if human personhood exists at the moment of fertilization, because human beings, what qualifies us as human beings is our full human potential, what we could achieve, not what we're achieving currently at our current stage of development, then an unborn child at the moment of fertilization also has natural rights. Now some people will argue, but the woman's right to liberty supersedes the child's right to life. Why? Because I can see her, because she's stronger, because she's more powerful, because she's actualizing her powers. All very arbitrary and subjective criteria. Instead, I think the only objective criteria for resolving a rights conflict, where you have the life of the child in conflict with the liberty of the mother, is to resolve it in favor of a criteria of the hierarchy of rights. Which right is necessary for the other right to exist? So, for example, liberty is a necessary condition for the very possibility of property. Right? If you're my slave, then I also own all your property. So if you have a conflict of liberty versus property rights, the person with the liberty right should take precedence, because that right is more fundamental. Well, the same thing is true with life and liberty. Which right is a necessary condition for the very possibility of the other right? Life is a necessary condition for the possibility of liberty, right? If you're dead, your liberty is a moot point. So therefore, life must be protected more fundamentally. What this means is that there are four very important principles which have been abandoned by Roe versus Wade in our society. First of all, the principle of most complete explanation. When we attempt to define a person only genetically and completely forget about the transcendental aspect of the human person and the incredible potentiality of the unborn child to engage in those same transcendental acts that you and I have potential for every day of our lives. Secondly, the principle of human potential. That we define the worth and value of a human being based on what you could do if you achieved your highest level, not according to the level of development you've currently achieved, such as whether or not you are a feeling, sentient human being. Third of all, the principle of natural rights, which was completely abandoned by the Supreme Court in the Roe versus Wade decision. And instead they came up with a decision of how to determine abortion based on a trimester, as if the age of which trimester you're in the womb has anything to do with whether or not you have natural rights. And thirdly, a complete abandoning of the hierarchy of rights. A hierarchy that by its very nature is objective in showing that life is the preeminent right. So my position on abortion, again, comes from a very personal perspective, that I think that men and women have a right to know the full realm of human happiness, human love, human quality of life, and human freedom. And that the greatest sense of happiness any of us can experience is the happiness that comes from committing our lives to the good of the other. But secondly, in a pluralistic society, in a very public sense, that I see some real egregious errors that the Supreme Court has committed when it has abandoned these four fundamental principles and instead made the claim that since we don't know whether or not the unborn child is a human person, we might as well give up and assume that it's not. So now what we have is people now violating the principle of non-contradiction. It's a person if you want it to be, and it's a person, not a person if you don't. To me, that is the greatest sellout of human personhood, human happiness, human quality of life, human love, and human freedom ever. And that is why I would hope that you would join me in being pro-life. Thank you.
Thank you, Mrs. Pauley. Dr. Dombrowski, Dombrowski, you have a 5-minute response.
I'd like to thank Camille for energetic defense of your position, very nice position. No ad hominem remarks, I love that. So I've been in these sorts of situations before where get a lot of ad hominem remarks. So thanks for not doing that. I'd like to make 7 quick points. First, I would like to hold on to this distinction between 2 different senses of humanity, being human in a genetic sense and then being human in a morally relevant sense. Whereas I think Camille wants to push it and say if you have one, you have to have the other. Just one thought experiment here. Notice that cancerous tumors are human in the genetic sense. Is it the case that we would think it immoral to cut out cancerous tumors? So you clearly have human genetic material there. These are living cells. That's the problem with cancer cells. They're living, proliferating. They're doing quite well, right? But I would take that as an example of something that could be human in a genetic sense, and we ought not to grant it personhood status. I'm just trying to pull the distinction apart there and suggest that there are 2 different senses of being human. Secondly, I don't see a problem between continuum thinking on the one hand and then threshold thinking on the other. I know some people are skittish about my view because they say, what I'm claiming is there's these gradual changes that are going on in the fetus, and then all of a sudden at some point it acquires moral status. I think those sorts of things happen in nature all the time, where continuum of changes leads to qualitative difference, as in, say, water at 36 degrees being lowered to 35 degrees, 34, with gradual changes, and then eventually there's a qualitative change when ice comes on the scene. So also I think that throughout fetal development, you could have gradual changes that are barely perceptible from day to day to day that could lead to a quite important qualitative change when the fetus starts to experience pleasure and pain on its own. Third, I've been concentrating on the threshold of moral patiency status when a fetus becomes sentient. I have not said anything about the highest reaches of morality. So Camille said a lot of interesting things, but actually a lot of which I agree with regarding the highest reaches of morality, but it strikes me that we're not going to get those out of fetuses, right? I mean, what we're interested in there is just what is going to be the lower threshold concerning which we're going to grant moral status to a being who is human. Fourth, I think that Native Americans are sentient, and hence they were worthy of moral respect. I don't think there's anything in my position that would make it vulnerable to the sort of genocidal claims that conquistadores wanted to make. Fifth, I'd like to go back to a phrase that Caleb referred to from, I think, the Roe v. Wade decision about when life begins. I'm glad we haven't wasted time on that question. I don't think the abortion debate is about when life begins. I mean, sperm cells all by themselves are alive. Egg cells all by themselves are alive. The question is not even when does human life begin, because I'm willing to admit, and I think anybody who defends a pro-choice position would be willing to admit, that the fetus in the earliest stages of pregnancy is human, right, in the genetic sense of the term. The question is, when does humanity in the morally relevant sense begin? And that's where the debate lies. Six, I'd also like to refer to a question that Caleb mentioned earlier about the concern with the viability criterion in the Roe v. Wade decision, that as science keeps pushing viability back and back and back, isn't this an unstable way to make decisions regarding who has legal status? My understanding is that scientists have not been able to push viability back. What they can do is have an increased percentages of late second trimester and early trimester fetuses that will survive. Okay, but as far as I know, there's nothing in the research pipeline that would make it likely that we're going to have fetuses, before the late second trimester, who are going to survive outside of the woman. And then you begin to wonder, would you want them to, without a functioning central nervous system, without a circulatory system that's in place. So, and seven, I wonder if, this will be the last point I make real quickly, so I'll keep to my time here. I am somewhat persuaded by Mary Ann Glenden's thesis that one of the reasons why abortion is such a big issue in the United States, in a way that it's not a huge issue in Europe, is the fact that we've never had a democratically elected legislature, say the House of Representatives or the Senate, pass an abortion law, whereas that did occur in Europe. So there are people with very conservative religious beliefs and moral beliefs in Europe who are opposed to abortion, but it's not as big an issue for them as it is for a lot of people in America, because it went through the European parliaments, right, and they passed, permissive abortion laws. So I do see that as a problem in American culture, that our our legislators have not bellied up to the bar and passed, abortion legislation. That there is some legitimacy to the sense that there were 7 people on the Supreme Court, right, who brought abortion law into existence rather than democratically elected legislatures, and that is a problem, I think, in America. I'm much more comfortable with the European situation where Congress people would vote on this. It would be a much better situation politically. So let me stop. Thanks.
Thank you, Dr. Dombrowski. Mrs. Pauley, 5-minute response.
And I think that last point is the only point I do definitely agree with you on, Dr. Dombrowski. This needs to be considered on a legislative level and not on a court level. 3 points that I want to make in my last remarks. The first is on the question of whether, Dr. Dombrowski brought up this question about, well, a human cancer cell is a human being, it's a being of human essence, and so therefore we wouldn't say that, and equating that with the unborn child. But there's a very specific difference between a cancer cell, for example, or a cancer tumor, and a single-celled zygote, or a fertilized egg. And that is this. In the 1970s, Dr. Jerome Lejeune, who was a very famous French geneticist, was the first to discover the full human genome present in a human zygote at the moment of fertilization. But it wasn't just the full human genetic code that he discovered in a human zygote at the moment of fertilization. It was a unique individual human genetic code, and that's the key here. That you're not just talking about a being that is human, like a skin cell, or a cancer cell, or a bone cell. You're talking about a being whose genetic code is different from the genetic code of the mothers and different from the genetic code of the fathers. The cancer cell is going to contain the genetic code of the host, albeit a genetic code that is mutated. But the unborn child, at the moment of fertilization, contains a unique, distinct, individual human genetic code that is different from the mothers and different from the fathers, and will be carried on the same genetic code throughout that being's life. So that is a very different being and a very different question than just a tumor. The second point I want to make is this, that one of the problems that we can have, when I was debating against a woman from Planned Parenthood, is making this claim that we can't really know. There's this line of continuum, or this continuity of when it begins and where it goes to, and how can you say when the exact moment is that the being becomes sentient, or the being has brain, brain waves are detectable at different points, or when the being is capable of being felt by the woman, say quickening, or when the being is capable of some kind of conscious thought. And so the problem then is we begin to say, well, we don't really know, and so it's very ambivalent, and since we don't really know, then the law has no business determining. The law has every business determining whether or not this being is a human person or not, because that's the only legitimate purpose of the law, is the protection of human persons. And if we don't make the case of trying to attempt to discover whether or not this is a human person, the law isn't doing its job. But there's a very important principle that you need to use when you are uncertain, and this is called the principle of non-maleficence. This is the most basic principle of all ethics. You violate this principle and you have no civilized standard of ethics. And this principle states that when you are uncertain about whether or not some harm may be committed, first do no harm. So, in the case of an abortion, if we do not know whether or not this is a human person, we have to assume human personhood is present until we can prove definitively otherwise. Why? Because if we don't assume personhood, we risk committing an egregious harm. Not just a harm against somebody's liberty, not just a harm against somebody's property, but a harm against someone's very life. The final argument I want to make is this. To remember that human beings, we are beings that can make choices, but we aren't the sum total of our choices. What defines us as human persons is that we have the capacity or the potential for greatness. Part of that potential for greatness is our capacity to care for the most vulnerable, the most defenseless, those who are the most in need and the most dependent. And those are the arguments that have been traditionally made by the pro-choice side to exclude an unborn child from personhood, because it is defenseless, vulnerable, and dependent. If we allow that to become our criteria to exclude individuals from human personhood, despite the fact that they have a unique individual, independent human genetic code, then I think we risk the very essence of what it means to be human in the first place.
Thank you, Mrs. Pauley.
sure that when the presentation that I was doing was intended to show some of the confusion within existing case law, and so perhaps I didn't make that quite enough clear. And so it's important to note that the light quote was from the majority opinion in Roe, and then similarly, the concern was with the pro-choice justices on the court were the ones who were concerned with the changing view of liability, and that's why the reason was to show why the transition occurred from liability or trimester away from that. I basically just want to end by talking about the existing makeup of the Supreme Court and sort of suggest that in many ways the two arguments that you've heard today are going to be are basically the two positions that you have on the Supreme Court with one swing vote, and we all know who the swing vote is. So you have, in many ways, you have the magic number is 9. You have 4 on each side of the case. The left side of the court is very, very concerned with individual rights, and in many ways, this is an issue of a debate of hierarchy. It's a hierarchy of rights debate that you tend to see in a lot of these cases. And so on the left, you do have this concern with the hierarchy of the woman's right as defined to an abortion over the right of the unborn child, the fetus, to be born. On the right, you have increasingly a new, deeper understanding of the interesting debates with regards to the rights of the unborn to be born, right? And those are the two arguments that you've heard. The middle is the swing vote is Anthony Kennedy. And the future of the Supreme Court case law is entirely going to depend, at least in the short term, on what Anthony Kennedy wants to do. And that's why Anthony Kennedy's very famous quote is his reference to the mystery of life quote in the Casey decision, which is to say that he has this wonderful statement about how the purpose of life is defined by our each ability to define the meaning of life for ourselves. But he doesn't really define what the basis of that new definition is. And that's why everyone is sort of uncomfortable with Anthony Kennedy. Because, I think his argument is ambiguous. It's difficult to know what it's based upon. And that's why it's also difficult to know where in the world Anthony Kennedy is going to go on this decision. And that's also why you're increasingly going to see, I think, at least in the short term, members of the Supreme Court reluctant to take on this position because, for all they know, Anthony Kennedy could go crazy on either side or the other. So the only thing they know is that they don't trust Anthony Kennedy. That's the one thing the rest of the court agrees on. And so that's why I think you're going to see the court reluctant to take on these decisions, specifically with regards to the moment of personhood or life, however you want to define it. What you will see, I think, are some cases going to the Supreme Court specifically on some of the lesser regulations and the rational basis test. I think you're going to see those cases making it to the Supreme Court. So as you look ahead and sort of how the Supreme Court is going to resolve it, my guess is they're going to try to avoid the fundamental question of personhood and life, and they're going to try instead to focus on the issues of secondary regulatory process.
Thank you, Dr. Henry. We will now start our question and answer section. Yeah, and if you want to ask a question, now is the time to text it. It's not showing up here, but because we have it over here, so we are searching through. Okay, question for our panelists is, do we really know when sentience arises in development, and how do we know this? So I think to start, we should try to reverse the order and let Mrs. Pauley go first. You've got 3 minutes.
Sure. Science can tell using scientific instruments. There are ways to detect that there is sentientness present in the unborn child, in the same way that you would detect it in somebody through, pain measurements and that sort of thing. So there are ways to detect it. What we don't know is if it's detectable. I mean, if the being is experiencing some kind of a sentientness earlier than our mechanisms are able to detect it. So that's what we don't know. But I hesitate to get involved in that argument any further than that, because once again, whether or not you have feeling, whether or not you are a sentient being, has zero to do with whether or not you are a human person. A pig is also a sentient being, but nobody would claim that that's a human person. There are far more things that qualify us as human persons than merely whether or not we are a sentient being. And so that to me is kind of an irrelevant argument and even a red herring. It's kind of similar to the argument of breathing. Whether or not you're a human person depends on whether or not you're able to breathe oxygen. But at very early stages in your human beingness, you didn't need to breathe oxygen in order to exist. So why would we exclude you from personhood because you couldn't participate in something that you didn't yet need to make use of in order to exist and develop? It's the same argument that sometimes people use, well, you don't have a beating heart yet, so therefore you're not a human person. But before 21 days, you didn't need your heart to beat yet in order for your development to occur. So why should we exclude you from human personhood based on that criteria? These are very subjective criteria that have nothing to do with your full human personhood or your full human potential.
Thank you very much. Dr. Dombrowski, 3-minute response.
Well, I think sentience is relevant in this debate because it's a necessary but not sufficient condition for moral personhood. And Augustine and Aquinas both would have agreed with that claim, okay, that if you don't have a being who is capable of pleasure and pain, that's not going to be a candidate for a sort of moral personality, right, that is somewhat distinctive in human beings. So finding out when sentience develops strikes me as a rather important matter, and has historically been seen as very important in the history of Christianity, and Augustine and Aquinas and many others. You're right that even pigs are sentient, and I think that's why animals have rights. I think it's immoral to slit the carotid artery of a pig unless it's necessary to do so. I'm slipping in arguing for vegetarianism here, which is not the subject of tonight's debate, but it seems to me that if a being is sentient, it has the right not to be forced to suffer or to be killed unnecessarily. So the burden of proof is on the person who wants to slit the carotid artery of a sentient being like a pig.
Thank you. Dr. Henry, do you have anything you can say on this?
There's increasing debate in law as to whether, speaking of sentience, whether sentience gives you rights and whether that means the animals have the right to sue in the court of law. There are some European nations that are playing around with that. There's only one case that has come before the Supreme Court with that argument, and the Supreme Court did not grant those animals rights, so no.
Okay, the next question is, what happens as our ability to measure or identify sentience or viability changes as technology advances? And I'll throw that to Dr. Dombrowski first.
Yeah, once again, it's not clear to me that the question as to whether or not a being is sentient is exclusively a scientific question. Okay? For example, there's personal experience that I have that I'm sentient, but I suspect that the rest of you are sentient as well, or you give me evidence to suggest that you are. I wouldn't want to exclude that sort of evidence, right? Personal experience of what it means to be a being who experiences pleasure and pain. Okay? Apparently, what makes that possible scientifically is a functioning central nervous system. Okay? So I think that it's not irrelevant to figure out when a functioning central nervous system starts in a fetus. And it's different from the question as to whether when individual nerve cells are present. Right? They're going to be present and functioning much earlier than when you have a central nervous system. So.
Thank you. Mrs. Pauley, 3 minutes.
Okay. I think the key here is to remember that it's not, but first of all, even if we were going to use sentientness as a criteria for human personhood, it's not whether or not you're capable of being a sentient being right now, but whether or not you have the power for sentientness to qualify as a human personhood. But even that in and of itself is extremely dangerous, and here's why. Because there are some people who have physical conditions that prevent them from experiencing pleasure physically. There are some people who have these physical conditions where their nerves react in such a way that everything to them is painful. And yet these beings are still capable of love, faith, sacrifice, self-surrender, compassion, generosity, and I would hesitate to exclude these human beings from personhood based on the criteria that they are no longer capable, even have the power to experience pleasure and can only experience pain. Furthermore, there are some beings who can't experience physical pleasure or pain at all because of their conditions. And are we going to exclude these beings from human personhood because they cannot have certain physical feelings, and yet they can have experiences that are spiritual, deeply spiritual, and can sometimes advance along the moral realm farther than those of us who are sentient. So I just think it's an extremely dangerous and very narrow view to take of the human person that excludes whole classes of beings from human personhood that should not be excluded.
Okay, thank you very much. Dr. Henry, do you have anything on this? Okay, moving swiftly along. This one is a very simple question, but it's one that's asked a lot and probably needs to be answered. What if a woman is pregnant due to rape? And I'll give that to Mrs. Pauley first.
Okay. Pregnancy due to rape or incest is a tragedy and should never occur, obviously. But there are three very serious arguments against allowing abortion, which would be the intentional killing of an unborn child because the woman was raped. The first argument is because the essential nature of the child does not change depending on the circumstances of his or her conception. I think we still have to set the ground rule that we have a unique, full human person with moral value and natural rights present here. So the question then is, what is the most compassionate response to the woman while not violating the life rights of another human person in order to try to make right a wrong? So that's the first question that has to be looked at. We cannot ignore the fact, because of our heart and our feelings and our love for the woman, we cannot ignore the fact that there is now another, if pregnancy occurs, another unique individual, human person who also has rights and deserves our compassion and our attention as well. But the second point is that it is problematic when we say that abortion is a solution for rape and incest. All of the statistics show that when a woman has a rape occur to her, she experiences severe trauma, and those traumas include self-hatred, fear, anger, loss of faith. When a woman has an abortion that she instigates, an abortion that she desired, not one that was forced on her, she almost always will self-report some if not all of those same symptoms of having fear, anger, self-hatred, loss of faith, anxiety, depression, all the same things that accompany rape. There's no statistical evidence whatsoever in any field, particularly psychological and psychiatric fields, that shows that abortion relieves those symptoms in women, and in fact it's quite the opposite. And my final argument would be, I just find it a very narrow solution to the problem of rape in general on a societal level. I think that you're the generation that has been taught to be compassionate because of service. You learned so much more about service than I did in my generation when I was going to college. And I think that you can come up with solutions to the problem of rape, and particularly pregnancy because of rape, that don't have to include abortion. We close our minds and think abortion is only the solution, and to me, I think that's degrading to women. To say, all I need to do is give you an abortion and then pat you on the head and send you back out to society, and you're expected to be just fine, and you're not. Because now you have not only the rape, but the compounded abortion on top of that. I think your generation can come up with far better solutions than my generation did for the problem of rape and abortion.
Thank you very much. Dr. Dombrowski, 3 minutes.
I'm defending a delayed harmonization view, and I think that a woman has a right to an abortion in the first 2 trimesters of pregnancy, for whatever reason. So it follows a fortiori that she could have an abortion if the pregnancy was a result of rape or incest. So it's no special case because I'm already willing to permit abortion in the first 2 trimesters.
Thank you very much. Dr. Henry, does law have anything to say about this? Okay. Okay, so the next question is, what does research say about women who have had an abortion, and how many believe, and why should they believe they made the right or wrong decision with this? And I'll hand it over to Dr. Dombrowski first.
I don't understand. I'm sorry, I don't understand the question.
Oh. Okay. Why should a woman who has had a pregnancy believe she made the right or wrong choice, depending on your view?
I understood the first question, not that one. Initially, you asked, what's the evidence that women might regret having an abortion or something? I don't know.
Okay, I think we'll just pass on that because it's not worded very well. So as a Christian, why should I choose your side? Dr. Dombrowski.
Oh boy. I'm all for a more agapic, more loving place. And I'm all for acknowledging the rights of all beings who deserve rights, who are the sorts of beings who are worthy of rights. I'm all for making sure that vulnerable beings are not taken advantage of. It seems to me that pre-sentient fetuses are not the sort of beings that can be harmed one way or the other. And it's not until they become sentient that they should be seen as vulnerable. I don't see them as children. I don't see them as persons. And this is an argument from tradition. It's not a terribly strong argument, but it's one that most Christians are not aware of. This is the dominant view throughout most of, the view I'm defending is the dominant view throughout most of Western Christianity. There was opposition to abortion before the 17th century, but it tended to be opposition to abortion on grounds of sexual ethics. So if you thought that in order to be moral, sex had to be within marriage for the purpose of having children, you would be opposed to abortion, because it would indicate that the sex that resulted in the pregnancy to be aborted was illicit sex. That was the standard reason why people might have been opposed to abortion throughout the history of most of Western Christianity. That's quite different from claiming that abortion is wrong because the fetus in the early stages of pregnancy is a person, hence to abort it is either murder or something closely approximate to murder.
Thank you very much. Mrs. Pauley?
You know, I actually take great issue with that. There are statements from the church fathers from the earliest time of the articulation of Christianity that would defend the unborn child by stating that abortion is opposed to the moral rule. And when St. Augustine and St. Thomas Aquinas were discussing the issue of the unborn and whether or not it was a human person, they were discussing this from a biological perspective of which they knew nothing about because they didn't have advanced biology as we have today. They were never claiming that the church changed its position on abortion and that the church should support abortion. That was never in any of their writings or any of their statements whatsoever. But the Bible does speak to this issue. You won't find the word abortion in Scripture in the way that Dr. Dombrowski, mentioned, but you will find reference to the unborn child and to the value of the unborn child. In Jeremiah, we are taught that before you were formed, while you were still in the womb, God knew you. And that word knew doesn't just mean that God knew that one day you would come about and knew what you would be like. The word knew, as used in the Scripture, had a specific definition. To know means to actually have, that God had you, that He held you into existence. And so what that statement actually means is, if we're going to take a scriptural perspective, before you were formed, while you were still in the womb, God held you into existence already. You were already a part of His mind and a part of the human family and a part of human reality. So I think Scripture very much speaks to this, but there wasn't a need at that time to say thou shalt not have an abortion because it simply wasn't as relevant as it seems to be today. It wasn't something that people did because of the church's stand on that.
All right, thank you. And that's all the questions we have. We saw a lot of mutual respect amongst our panelists. Please give them a round of applause. And if the panelists wish to stay after and answer any questions, you're free to ask them. We've still got some more refreshments in the back, and have a great rest of your evening.